So I'm Brian Chapman, owner of MBI Worldwide. I have Jolene Chullen with me. She's Executive Vice President and my compliance manager. I've worked with these much. So her do the beginning of the presentation, and then I'll follow it up as we go on. But so there's lots of change 2013 regarding background checks. Lots of changes. There's lots of people involved. There's a lot going on. President Obama has expanded the Second Chance Act, which pretty much means anybody getting out of prison, deserves a second chance. So there's a lot of legislative changes going on across the country with each state and with the federal legislation to try and make that equal, not only for jobs, but for financial, for bank loans, mortgage loans, pretty much the whole gambit. But it does affect the hiring process as well. We're going to discuss the new government entity, the Consumer Financial Protection Bureau, the FTC, which used to regulate our industry. I'm going to talk a lot about EEOC, which I know you guys have heard plenty about, but I'm going to tell you what they're doing with background checks. And then we're going to discuss a little bit about private attorneys and how they're starting to affect your hiring process as well. But we're pretty much getting hit from 3 different directions out there during the hiring process. So I'm going to turn this over to Jolene right now so she can talk about the new government entity called the Consumer Financial Protection Bureau and how it affects your hiring.
Yes. Brian kind of talked a little bit about President Obama coming in and making some changes. One of those changes was in 2010 underneath the Consumer Financial Protection Act. He separated the Fair Trade Commission from having the primary enforcement and had the CFPB and the FTC had the shared enforcement authority. So kind of what does that do in the means of background checks? They have the primary rulemaking authority over the Fair Credit Reporting Act. And what does that mean? You think mainly credit reports, but no, it actually is credit and background checks or consumer reports. It is the Bible of the background checks, and it also regulates you as the employer how you use consumer reports. In 1998, on top of that, they had the Clarification Act of the FCRA, and that also goes back into further detail of what that regulation is. So if that's something that you haven't viewed yet, definitely get a copy of that and review that in great detail. The enforcing of the CFPB is it enforces the FCRA, which we already talked about a little bit. It investigates business and can issue fines and civil penalties. And it investigates consumer reporting agencies. So that would be kind of our role. And if you guys are actually doing any type of investigative work, verification checks or those types of things internally. Both the CFPB and the EEOC are kind of having a turf war right now. They're kind of trying to prove who they are. So you're going to be seeing an increase of suits due to that. Some hot topics. The 2 big things that we're going to talk about here would be your adverse action and the documentation. The adverse action process obviously would be when you deny an applicant based off of a consumer report in whole or part, you would then issue that adverse action. So we'll talk about that here in a minute a little bit more. The new verbiage that we're referring to here underneath the legal documentation would be your summary of rights and your notice to users of consumer reports. The old FTC needs to be removed from those documentation, and the new CFPB would need to be placed on that. And as of January 1st, that was a requirement of 2013. So again, lawsuits have been coming strictly just out of people not putting that new agency on your reports or your information. The pre-adverse action and the adverse action notice, obviously there's 3 parts to the pre-adverse action, which would be issuing the summary of rights, the actual notice of the adverse action, and the copy of the consumer report. A lot of times people will give them a copy of their rights or a notice that they're not going to hire them, but they fail to actually give that copy of that report. Again, something that they're looking at. The minimum time then that you are allowed to give your applicant underneath the FCRA would be 5 days. That's business days. and that can actually be extended. So if you want to choose 7 days or 10 days, that's something that you can then do, but the minimum is 5 business days. And the prior piece of that puzzle would then be to issue that final adverse action notice. This is something, again, you guys can do internally, or you can have your third-party entity do that for you. The final piece to the adverse action would be, again, to make sure that you have all your documents updated and that you're handing out the right documents. Part of the notice of the pre-adverse action and the adverse action is that you have to have your party vendor, whoever that might be, their address has to be listed on there, and a toll-free number for that applicant that they can contact and either rebuttal that or have additional questions about their consumer report. A big thing that is pushed out there is that if you don't have a policy for adverse action, that you put a policy together, that whether you have a 1-person HR team or a 15-person HR team, that everybody's on the same page and someone isn't doing something a little bit different, that policy and everything going on within your business is the same. Another suggestion would be to have a review team. Even if you have a 1-person HR team, that you have someone, whether it be your vice president, your CEO, review that process with you, and that you're not making the only decision on that adverse action.
And back, in the good old days, when we hired whoever we wanted, adverse action wasn't done very well, and still actually isn't being done, which is one reason why it's being enforced. We used to say, well, we didn't hire him because we liked their hair color, or we hired Joe Smith because he was more qualified than John Smith, even though John Smith, we hired him because he actually had a felony. So we were able to get away with not doing adverse action because it is a pain in the butt. But what's happening now is CFPB and EEOC are aggressively seeing what your policy is, and they're gonna pull how many you're doing when they come into your office. They're gonna say, how many adverse actions have you done this year? Let me see them, or what's your policy on it? And if you pull 1 or 2 out of the box and you hire 500 people a year, or you're going to get in trouble. So make sure you have something in place. Get with your consumer reporting agency, which is your background company, or your HR legal counsel, or you can call us. We'll help you. Just set that up, set that policy up, kind of help you out with there. If you don't want to mess with adverse action, every consumer reporting agency offers to do it for like $2 or something. So every one of them can do it for you, so it can be off your back, but so you're doing them. But the old days of not doing them anymore, it's going to be out the window. And so I'm going to tell you why here in the next slide, because we're going to talk about EEOC and their hot topics. So I was starting to make a list of the hot topics for EEOC, and it was about 150 items. But so basically, everything that negatively impacts them get ordered. And in our case, in our industry, it's background checks. So they've been concerned for a long time about how background checks affects minority groups. They believe it creates a disparate impact on minority groups. Because more African Americans and Hispanics are tested than white people. So they believe it negatively affects that class of people, that minority class. So they are getting involved pretty hot and heavy with background checks and how you are doing it, how the employers are applying it during the application process. April 25th, 2012, they came out with their enforcement guidance, basically their opinion on how background checks should be done. The problem with this enforcement guidance is they didn't ask anybody for help. It's a board of 5 people, basically political appointed positions in Washington, D.C., and they created this guidance. Again, with nobody's help. SHRM tried to get in and talk to them. Our association, the National Association of Professional Background Screeners, we attempted to get in there and talk to them because we knew it was happening. Our company attorney is the leading EEOC attorney in the country out of Chicago, and she actually spoke with one of the board members quite frequently about trying to get some certain changes that she had heard the rumors that were in the guidance, but they wouldn't talk to anybody. They wouldn't put it out for a draft. They did. We were, according to our sources, we were able to get a couple things out of it, but mostly they just issued this thing with no one's opinion except for their own. So it's pretty harsh. It's pretty it creates a lot of few hurdles in the background hiring process. So I'm going to tell you what a couple of those things are. Basically, no longer can you have blanket policies, felony policies. If your company policy says we don't hire any felons, you're going to get in trouble. That can no longer happen. If they come in your office and they see you're doing that, then they are going to give you a minority claim that you're discriminating against minorities. So we have a neutral policy, like I said, disproportionately screening out individuals based on race or national origin, which is the blanket felony policy. 27% of Americans have a criminal record. I know that's a surprising number, but it is true. So basically 1 out of 4 people coming in your office is going to have a criminal record. So you need to partner up with vendors like us to help you filter these people out if you don't want them there. But it's going to be a little more work now. EEOC is recommending, they're not quite enforcing yet, but they're recommending that you not ask about convictions on job applications. And I'm going to cover that again in a little bit, but that's basically the ban the box effort, which I know SHRM is trying to cover right now quite a bit as well. So this is the 3-prong test has been around for a long time. Nobody's really been using it. This came out of some court cases several years ago. Now EEOC is trying to mandate it. They're calling it an individualized assessment. And the 3-factor test is the nature and gravity of the offense or conduct, the time that has passed since the offense, and the nature of the job that they're applying for. So you can give an example of a guy comes in with an embezzlement felony, and you're trying to hire him for a factory line stamping valve covers. Well, embezzlement and stamping valve covers do not apply to each other. So if you didn't hire him because of that embezzlement, EEOC is going to come down on you for that. The EEOC recommendation, and this is back to the pre-adverse action that Jolene was talking about, is inform the applicant that he or she may be excluded based on their past criminal conduct. You need to provide an opportunity for that person to complain about it or appeal it, and then also you need to consider whether the individual assessment shows a policy should not be applied to the applicant. And this is, again, the pre-adverse action notice. So you need to sit down if you haven't already done it, and these are pretty much the 3 categories of crimes and how it applies to your facility. Again, if you're stamping valve covers, are they working around 50 people in the factory line? So, crimes against persons, maybe use those type of things. If there are lots of aggravated batteries, lots of violent crime, you don't want them around a lot of other people. If they work pretty much alone, then it kind of doesn't affect, the other people around them. So, which your either legal counsel or your consumer reporting agency can help you policies. As you know, EEOC, when they come into your office, the burden of proof lies on you. They're gonna dig and dig and dig, and as they keep finding things, they're gonna have you prove why you're not discriminating. They want you to show why you're not discriminating against applicants or even current employees, promotional employees. They want to know how you have linked the crimes with the job positions. So you need to have documented policies on these. And they're going to ask you, they're going to sit down with your staff and, how are you evaluating who fits the standards of your policy and your positions and the criminal records? Do you go through each report and make a decision, or you just have a blanket policy? Again, back to the blanket policy. Have your legal counsel review and make recommendations, and I'm going to caution you here. What we have found in our customer base is that a lot of smaller companies have a general counsel that they've had for 30 years, and it's a guy that's great with contracts but knows nothing about HR and knows nothing about EEOC, and he's saying, "Oh, it's okay if you do that." You as an HR person need to say, "No, it's not okay. Here's what's going on. We need to fix this." And either make him or her fix it, or you just need to hire an outside counsel. Like I said, we can recommend our counsel in Chicago. It's worth the money to get your policies in place, because I'm going to show you some numbers here in a minute of who's paying what, how much the things are, the litigation costs. Future expectations for EEOC, you know, they're going to keep aggressively enforcing all these things. The criminal history, they do not like running a criminal history on applicants. They just don't like it. They know, they've come out with an opinion, said they know it's needed, but they do not like it, and they are not supporting it. So they're trying to do everything as possible to make things equal among your applicant pool. 2012 saw a decline in overall litigation, but we saw an increase in systematic discrimination, and that's where we're getting the class action lawsuits. And this is where we'll get in some big trouble. I'm going to cover that in a second as well. This is their EEOC Strategic Enforcement Plan for 2013, and they're targeting eliminating barriers in recruitment and hiring. Back to, they don't like running criminal history background checks. So they're, you know, as you see, the second bullet point, they're addressing emerging and developing issues. That's very vague, and that's where they're just going to do whatever they want, basically, when they come into your office. So what should you do now? Again, take a look at your application and decide whether you want to keep the box on there or not. There's a big effort going across the country to ban this, ban the box. Nobody, I don't think any state has actually put it legislatively overall. But for instance, Governor Quinn this summer in Illinois took it off of all state applications. So as part of the ban the box effort, trying to make things equal, people apply for the state of Illinois. And what you're going to get is your pool as you bring them in, and then you're going to get a bigger pool of people coming in, and then you got to run the background checks after the interviews. So it's going to waste a lot more time of doing interviews and assessing an applicant, and then run the background checks. And then you can still exclude them based on your policies, but it's just going to create more work. So there is a big effort out there for ban the box. Be aware of it. Kind of stay in tune with it, depending on what state you're in. But like I said, Illinois did just pass for state employees. Need to be consistent with your hiring. This has always been said, and I have a little example there. Employers should consider whether they're ignoring drug convictions against young white job applicants, writing them off as youthful experimentation, or, oh, they were in college, and, you know, it's just whatever. But when you get one of a young black job candidate, you think something's a little more sinister, like drug dealing or gang involvement. So be careful with those kind of personal opinions. So EEOC, just be aware of what's going on out there. Talk to your CRA. Work in partnership with your consumer reporting agency, your background company. All of us out there are a little more than vendors these days. We're definitely partners. We know what's going on. If you have a decent company, we're going to Washington D.C. next month to discuss some legislative issues. We go every year. Jolene and I both are on our board for our national association. We're very aware of what's going on. Your consumer reporting agency should be as well. They should be giving you information through newsletters, through email blasts, monthly of what's going on out there. And you need to be reading those things too. Don't ignore them, because all these changes happened in 2013, and a lot of people don't even know. We still have all the email blasts and newsletters we send out. We still have customers that are like, oh, I didn't know those disclosures changed. But we're constantly trying to one-on-one call our customers and say, hey, have you updated? Have you updated? So we want to keep our customers protected. So private attorneys are getting involved. This is a market for class action lawsuits. Areas. In Los Angeles, Chicago, and in New York, there's billboards up that says, you deserve to work. Have you been discriminated because of your background check? Call 1-800, I'll sue them for you, whatever. But this is a new hot market for litigation. And they're making money. it's working because they have EEOC on their side, and they're causing a lot of problems within the industry with employers. So be very careful. Civil action can be brought against your employer, against you guys within 2 years after the plaintiff's discovery of a violation of the FCRA, and that's mostly related to adverse action, or 5 years of the violation. So it's a long time. Make sure your policies are in place. Make sure you have documentation. Here's some recent settlements just in 2013. I'm going to skip the first one because I'm going to talk about that one. But a national retailer paid $3 million in a settlement, class action settlement. $7.5 million. These are class action settlements against these employers. The local small healthcare facility, we were actually involved in this, and they didn't do proper adverse action. And again, this is where I came up with the whole general counsel, your local attorney not knowing what they're talking about. They had one of these attorneys that didn't understand EEOC, FCRA, and the hiring process, and he gave them really very poor advice. And they ended up having to settle, fortunately, with one person for $22,000 because they didn't hire an applicant. They could have went class action, and they didn't, and we actually had to help them with our attorney to say, hey, you need to fix your system. So this is happening to local companies. So if EEOC doesn't come in or a CFPB doesn't come in, you may get hit by a private attorney. So just be very careful of that. You need to weigh how you should, the employer should weigh their relationship. You review all applicants identically. Again, be consistent. You need to have a matrix requirement policy for each position. You know, we kind of talked about that already, but create a matrix of the position and what crimes you and your attorney thinks shouldn't be in that position. You know, obviously a CFO shouldn't have an embezzlement felony. You know, that's obvious, or any kind of theft. But stamping valve covers, you know, there can be lots of crimes that, you know, someone could be working that job position. Again, back to your attorney. When in doubt, reach out to your attorney. We talked about ban-in-the-box effort. Credit reports. About 15 states have banned credit reports in the hiring process unless it's a financial company or the salary, I think, is over $75,000. Then you can run a credit report on the background check. So we've been recommending for years not to run credit reports. Our company has anyway to our customers because they're a hot topic. But and all this is happening because of the recession. People have bad credit and they can't get jobs. So this is a big effort right now, sweeping through the country. So don't do them if you don't have to. You know, you can find out all the information, other information through criminal records and driving records and other stuff. Marijuana laws. Several states are passing legalization of marijuana. The things you have to know here is that marijuana is still a federal crime, so you can still not hire because of it. Also in drug testing, you can still not hire because they have a positive drug test, even if they have a marijuana card. Still not hire because it's still a federal crime. So kind of be watching these laws and be aware of where they're at. In Illinois, we don't, well, actually we are getting ready. I think we did just pass one, or we're getting ready to pass a marijuana law. But talk to your attorney about this too and how you navigate around this law. California right now, if you, as a consumer reporting agency, we cannot report marijuana and misdemeanor marijuana convictions to you. It's against the law. We are committing a felony by reporting a misdemeanor marijuana conviction to you, and you are committing a misdemeanor. Yes, and you are committing a misdemeanor if you use that marijuana conviction against a California employee. So that's going to happen too. You know, everything California does, Illinois does. So be aware. Kind of watch those. We've already talked about the changes in 2013, and pending change for 2014 is kind of these three things: ban-in-the-box, credit reports, and then the marijuana laws, and increasingly more aggressive enforcement from EEOC and CFPB. So here are my recommendations. This webinar will be up later for you guys to pull off and download, or you can make notes on these. But you should, arrange for review of your background check consent forms, whether it's through your attorney or through your consumer reporting agency. Call them and make sure they're up to date, and they changes. If you're using a small company or a private detective for your background checks, they may not know of these. Make sure they're aware of them, and so they can get you the proper documentation. Through a review of these forms, employers should implement procedures to help ensure that adverse action notices are sent at least 5 days after the pre-adverse action notice. So send those adverse action notices out, and then set up a policy where you're either calendared to send out the 6th, 5th, or 6th day the adverse action notice. Number 3 is a difficult thing for us because we run into this all the time, but employers should be mindful of their duties when contacted by a CRA about information provided about a former employee. These are reference checks, basically. So 2 things with reference checks. I know we do hundreds and hundreds of these every week, and sometimes we get, I can't tell you anything. Sometimes we get people with telling us everything. Sometimes we just get name, rank, and serial numbers. For sure, you need to give at least name, rank, and serial number, because if you don't give us anything, we report it as this company would not verify this applicant's employment. And so that is a negative impact on that consumer report, because we can't verify he was employed the last 2 years. So another employer may not hire him because of that. So you need to at least make sure, doing at least a neutral policy of giving name, rank, and serial number, but you can give, most of you know, just factual things about the employee. And I would go to that angle more than, I'm not going to tell you anything because I don't want to be liable for anything. Because you are going to be liable if you don't give anything, because that also creates a negative impact on the applicant. This is a good one too right here. Those of you that have multiple companies within one, make sure the disclosure has a particular company they're applying. 3 entities, attorneys, EEOC, are going to go after the corporate structure instead of just the one employer. Same thing with, Jolene didn't cover it, but on your releases, on your adverse action notices, make sure the proper consumer reporting agency is listed on the consumer adverse action notices. Because if it's not, they'll be calling a former consumer reporting agency that maybe you just switch vendors, and that's also illegal. They have to be able to call us so we can make the changes. So I think we have just time. Yeah, we have time, Aaron. If there's any questions, we can email you or...
Yeah, let me check and see if there's any questions.
How they communicate with you here.
All right. It doesn't look like anyone has typed questions in the messaging function. You do see Brian's email and Jolene's email if you have any questions, or feel free to contact me at Extra Help. Also, I would like to provide you with my email address. If you specifically want a copy of this presentation, I can make sure that you get a hold of that. My email address is ekopec, K-O-P-E-C, @extrahelpinc.com. I want to thank everyone for tuning in today, and like I said, feel free to send emails out, ask any questions that you may have. Our appreciation. I'm sorry, go ahead.
If everybody, you can see our links down there. If everybody you want to follow our LinkedIn or our Facebook, we send out, pretty much weekly, we send out updates, legal updates. About 50% is boring legal update stuff, about 50% is comedy. At least we'll try and make you laugh a little bit. That way you'll stay on our blogs. But check our blog, check Extra Help's blog. Keep up to date because there's changes going on every month. Like I said, we're going to Washington, D.C. Next month in April for a legislative conference, and we're going to be speaking with some representatives from the EEOC. So we'll have more information when we come back from there. But just try and follow us so you can kind of keep up to date, or your CRA if they have a lot of social media stuff. But I appreciate everybody come in and listen to me.
All right. Thank you, Brian. Thank you, Jolene. And the presentation will be available on the Extra Help blog probably towards the end of the week. So if you want to go out and look for it there or send us an email, we'll make sure that you have access to that. Thank you, everyone.
Thank you.